Representative Newbury.
Thank you, Mr. Speaker. Back to my theme of whether what we're doing here tonight actually codifies Roe versus Wade or not. When I looked at the legislation, and I'm going to direct you, so you have it on your screens. If you look at page 7, section 7 on page 7, there's one isolated provision. I say isolated because it could come out or stay in. It wouldn't affect the rest of the legislation. It has to do with health insurance benefits. And the legislation, section 7 is existing law. It's only making a minor change. The words "or any city or town" is being struck out in the bill that we're looking at tonight. And when I first saw that, I thought that was kind of odd. It has to do with whether or not the state can offer abortion coverage in insurance, not private, but health insurance for employees. Under the existing statute, and even under this revision, the state can still bans coverage for abortion. However, if we make this change, it will allow cities and towns to offer health insurance plans and abortion coverage. Now, I first saw it, not having sat through Judiciary Committee hearings, so I'm not in Judiciary, I thought, is this because a particular city or town wanted the change? I didn't know the reason why. So yesterday I went and I asked two members of the Judiciary Committee, both attorneys, one who voted for the bill, one who voted against it, what the reasoning was here. And it turns out the reasoning was, according to the committee, lawyers, clerks, whoever drafted the bill, again, I'm not in the committee right now, so I don't know, the reasoning was that there was a case that ruled this provision unconstitutional. So I was curious and I looked into that. One of the things, and this is a bit of an aside, but it relates directly to what my amendment is here that I'm about to offer. One of the things that strikes me is we keep hearing about codification of Roe versus Wade, and I think there's a lot of reasons for that. Part of it's just simplicity. Everybody's heard of Roe versus Wade. It was the landmark abortion decision that legalized abortion. Whether you like it or not, that was the law of the land as of 1973. What's I think a lot of people forget is that the Supreme Court came closest to overturning it in 1992 with Planned Parenthood versus Casey. That opinion had split. There was a plurality of 3 judges that carried the majority, and they explicitly upheld Roe, but they did fundamentally change some of its tenets. So really what we should be doing, if we're interested in complying with the constitutional law currently in place, is codifying our laws to make them match Planned Parenthood versus Casey, not Roe versus Wade. We're not doing that, I suspect, for 2 reasons. One is the aforementioned fact that Roe v. Wade is, I mean this in a serious way, catchy. People understand it. The second is that Planned Parenthood versus Casey loosened the constitutional restrictions on abortion regulation. This case is a particular example. The case that I was referred to that dealt with this specific statute came from the U.S. District Court in Rhode Island in 1984. It was titled National Education Association of Rhode Island versus Joseph Geary, that would be the governor, and it was a challenge to this provision. Then District Judge Pettine, who retired, I believe, in 1992 and retired senior status in 96, wrote the opinion, which I have, and I'm not going to read the whole thing, that the case dealt with several other challenges, and there were different legal theories. But at the end of the day, what he concluded was this provision that we're striking out in 1984 was unconstitutional. It was unconstitutional because he applied the strict scrutiny standard of Roe versus Wade. I won't read the whole thing. I can give you the citation if he wants to read it later. But basically he said, strict scrutiny must be applied to it. Strict scrutiny is warranted in any event because, for the same reasons set forth, etc., the impact of the statute on the abortion rights of female employees is sufficiently significant to trigger strict scrutiny. Indeed, the impact is unquestionably more significant here because the statute flatly bans insurance coverage for abortions rather than merely imposing a surcharge on or restricting the availability and so on. Under the strict scrutiny standard of Roe versus Wade, he was probably right. The decision went to the First Circuit. It was affirmed in 1986 with a 1-paragraph opinion where they basically adopted his reasoning. The problem is Planned Parenthood versus Casey changed the strict scrutiny standard. Specifically, that decision, which was passed in 1992, if you look at the formal Supreme Court opinion, it begins on page 833 of the Reporter. So I'm referring to page 874. This is not 874 pages of the decision. It's page 874 in the Reporter. I'm going to read you the paragraph which is referenced here. Numerous forms of state regulation might have the incidental effect of increasing the cost or decreasing the availability of medical care, whether for abortion or any other medical procedure. The fact that a law which serves a valid purpose, one not designed to strike at the right itself, has the incidental effect of making it more difficult or more expensive to procure an abortion cannot be enough to invalidate it. Only where state regulation imposes an undue burden on a woman's ability to make this decision does the power of the state reach into the heart of the liberty protected by the Due Process Clause. In other words, they change for stuff exactly like this, the standard from strict scrutiny, and I would tell you, if you look at Supreme Court history, anything challenged to strict scrutiny is almost always thrown out, to undue burden. So the question now is whether this existing statute establishes an undue burden. Based on the language of Planned Parenthood versus Casey, it's a very good argument that it does not. The reason I bring all this up, and Mr. Speaker, maybe I should move my amendment now, and then I'll finish up.
Proceed.
Hey, look, we're here. This is serious stuff. I know I like to have some fun on the floor and all that stuff too, but if we're going to be here all night, we can be here all night. The people are watching. It's important to everybody on both sides. Mr. Speaker, my amendment is LC 000518/14.
Representative Newbury moves Amendment LC 000518/14. That is seconded by Representative Nardone, Whip Chippendale, Representative Price, Representative Quattrochi, Representative Place, Leader Filippi, Representative Roberts, Representative McLaughlin, Chairman Corvesi, Representative Ucci. Proceed.
Obviously, we can all call the amendment up on the screen. Like a lot of our amendments, you can't tell by looking at the amendment. Very simply, all this does is strike Section 7 of the legislation before us. And again, Section 7 is almost all existing law except for the change you see in the bill. I'm putting this in for a very simple reason. If we change this law, which was ruled unconstitutional under a different Supreme Court standard 30 whatever years ago, we will be opening the door to potential, again, incremental and small, but public funding of abortion coverage and insurance policies. Now, you may favor that or you may not, but the bottom line is the rationale that I was given for why we're changing this at all is a flawed rationale. I don't know why. It's, I looked into it when I was told, but the bottom line is it's not really unconstitutional, folks. It was ruled unconstitutional, but the law that it was ruled unconstitutional under has been fundamentally changed. So I think we should leave this in here, leave the prohibition on there, and if somebody wants to challenge it, let them challenge it under the new standard. Well, it's not new anymore, but under the Planned Parenthood versus Casey standard. That way, if people are truly concerned about public funds going to abortion coverage, they have the chance to keep it from happening. If they want to go to allow public funds to go to abortion coverage, you're going to support the bill and you're going to shoot to my amendment anyway, but it gives everyone the choice and the option and lets you tell your constituents where you stand on the issue.
Representative Blasiuski.
Thank you, Mr. Speaker, members of the House. I rise in opposition to this amendment. Leader Newbury mentioned that this will open the door. It will not open the door. We are conforming, Section 7 conforms our state law with existing law under existing jurisprudence. He references the case law that is directly on point, NEARI versus Geary, which was affirmed by the First Circuit in 1986. And the case is directly on point. And there's nothing about the change in the level of scrutiny that leads to prior precedent being overturned. There's no this First Circuit decision, which affirms the district court, remains on the books as a good law and has been operated under since that affirmance in 1986, because that is the current state of the law. So for that reason, ladies and gentlemen, we are just conforming our law to the current law in conformance with case law. So I urge its defeat. Thank you.
Representative O'Brien.
Thank you, Speaker. I'd like to be marked in the affirmative on amendment number 3, please. Won't change the result.
So ordered. Representative Newbury.
Just very briefly, the problem with Deputy Whip Blasiuski's argument is I'm sure he had it prepared before we came down to the floor, but I also know that he probably was unaware or hadn't thought about the change in scrutiny between Rhode and Planned Parenthood versus Casey. The 1984 precedent is still in the books, but the rationale for it is no longer good law, which means it ruled it unconstitutional, but it may not be unconstitutional. It's a good argument that it's not, so we should leave it on the books if you don't favor public funding of abortion coverage, and let someone else challenge it and get a ruling up to date. Thank you.
Representative Blasiuski.
Representative Newbury, I addressed your point specifically. A change in the scrutiny does not overturn these cases. It has not overturned them. It does not overturn them. Thank you.
Representative Newbury. How many times? I think you're over, but go ahead.
I'm good, sure. I didn't say it overturned the cases, but you know as well as I do, if you read Judge Pettine's opinion and you read Planned Parenthood, he applied a strict scrutiny standard. And we don't know what he would have done if he'd had the plan, because it was in the future, and we don't know what a judge would do now. So there's no point in debating this back and forth. I think we all know how we're going to vote, but let's be clear what we're arguing about here. And I'm sorry I didn't tip you off to what I was going to say beforehand.
Thank you. And I was wrong. It's your amendment, so you can get up as many times as you want. There are no other lights. Clerk, unlock the machine. If you're in favor of the amendment, please vote green. Those opposed, red. Has every member in their seat voted? Clerk, lock the machine. 25 in favor, 45 opposed. The amendment fails.